Breakfast Basics series, organized by the Young Lawyers section of the Chicago Bar Association. Today, our presenter is the Honorable James A. Shapiro, who served as a Circuit Court of Cook County judge from 2007 to 2012, former Assistant United States Attorney, former adjunct professor at John Marshall Law School, teaching about federal courts. He has a litany of published articles and other papers, and recognized as a super lawyer and several other professional distinctions over the course of his career. Without further ado, the Honorable James Shapiro.
Thank you. Thank you, Adam. Appreciate it. Okay, first correction of the day. Anyone can tell? Anyone? This one? What's wrong with this placard? Should say RET at the end of it in parentheses. RET retired. Okay. And honorable without the retired suggests I'm a sitting judge, and I'm not anymore. I'm a retired judge. So RET in parentheses is appropriate for sitting judges. I'm going to start today with a quote that I found. I keep this quote file in my iPhone for quotes that I like, that I get in my word a day email. So this one I liked. We should not write so that it is possible for the reader to understand us, but so that it is impossible for him to misunderstand us. Anyone know who said it? Anyone? Yeah, I didn't know who this is either. Quintilian, Marcus Fabius Quintilianus, a rhetorician, obviously in the Roman Empire, circa 35 AD, I assume, through 100 AD. So he was a rhetorician, I guess, like Marcus Aurelius. Who's the famous writer? Cicero, right? Cicero, right? Okay, so I've submitted. I've given you a grammar quiz to start, and many of you filled it out. I don't know if you folks online at the webinar got the grammar quiz online. Obviously, I couldn't collect the grammar quiz from you. This is sort of spontaneous, and we'll start with that. I noticed some of you did really, really well in this thing. How many of you got principal? Got principal, right? You got principal? Yeah. These are some of the most common errors that I see in legal writing. So I started out with that. Yeah, principal there is L-E, not A-L. Okay, some people use the mnemonic. Your principal is your pal. Probably not in school. And principal, L-E, is like a legal principle. That's a very common mistake that I see. Was the entire basis for the state Supreme Court's ruling. Many of you did get the capitalization problem in state Supreme Court. Only the U.S. Supreme Court, you capitalize the Supreme in the court. Okay, state Supreme Court is lowercase. And then in the next sentence, the court, again, you capitalize the C in court only for the U.S. Supreme Court, not for the state Supreme Court. Many of you also got the, and some of these are easy, some of these are much more challenging. Emily got the most challenging thing, I think. Thank you, Emily. And kudos to you. Reject the notion that most prospective jurors, most of you got prospective jurors, that was one of the easier ones, would exercise preemptory challenges. Okay, some of you got preemptory versus peremptory. That's a tough one. Peremptory is kind of arbitrary, kind of your right without explanation. Of course, with Batson now, you do have to give an explanation, a race-neutral explanation, if you're challenged on it. But traditionally, peremptory challenges were at your wish, just without explanation, just your own objective, or rather your own. For your own subjective reasons. So preemptory is something different, something having to do with preempting or heading off something. Now the tough one, I think the toughest one, is jurors disinterested in jury service. Okay, who knows what disinterested means as opposed to uninterested? Okay, yeah, Emily got this one. This is the one Emily got. You want a disinterested judge, but you don't want an uninterested judge. Okay, disinterested means impartial. Uninterested means not interested. Okay, Brian Garner, the doyen of legal writing, if you will, says that the distinction is fast fading, and it really is. I see this all the time. But he thinks it's a distinction worth preserving. All right, and I agree with him. I think it's a distinction worth preserving. Disinterested, there are a lot of other words for disinterested, like impartial, but they're two pretty different meanings. Disinterested traditionally means impartial. Uninterested means not interested. So you do want a disinterested judge and a disinterested jury, for that matter, but not an uninterested finder of fact. Could excuse themselves irrespective. One person I saw said replace it with regardless, which is perfectly okay. Regardless is right. The tricky aspect of that is to fool people into thinking that irregardless is okay, which it's not. Irrespective is fine. Okay, is not incorrect at all. But the trick is that it reminds people of irregardless, which is incorrect. And it sounds a little bit like, or it starts to sound a little bit like irregardless, but irrespective is fine, and regardless is fine too. Regardless of the irrespective, or regardless of the effect it would have on other potential jurors. This is one of the most common, if not the most common, typos or problems I find in legal briefs, both as a judge and otherwise. It's effect with an E. Just think of it as affect is usually but not always a verb. Effect is usually but not always a noun. Okay, the exception to affect being a verb. Effect being a verb is the psychological term affect, which means emotion. And effect can be a verb to effect a change or effectuate a change. But usually effect is the noun and affect is the verb. Very common problem I see in legal writing. And I taught legal writing. I started my teaching career actually teaching legal writing at Loyola, and so these are anecdotes or vignettes from my legal writing experience, as well as appellate advocacy at John Marshall. Okay, the state Supreme Court, which is correct, lowercase, all lowercase, is located in the state Capitol building. Okay, Capitol should be OL, not AL. Okay, the building is OL. A lot of you got that one, I saw. Capitol is the capital of the United States. The capital, Springfield, is the capital, and the Capitol building is located. Capitol building with OL is located in Springfield. The amount of cases it handles is staggering. Okay, this is a very common problem I see. It's number, and a lot of you got that. I saw it's the number of cases it handles is staggering. Anything you can count, you have to use number or fewer. Okay, anything you can't count, which lawyers popularly call fungible, you can use amount and less rather than number and fewer. Okay, more is fine either way. The U.S. Supreme Court is correct, capitalized. On the other hand, located in the U.S. Capitol. Okay, some of you got that, some of you didn't. The U.S. Supreme Court is not located in where Congress is located in the Capitol building, the way this is spelled. It is located in the capital of the United States, Washington, D.C., so that should be AL and probably lowercase, definitely lowercase c. Handles far less cases. Okay, that should be far fewer cases. I saw a number of you got that. One of its most recent was that of Jesus Garcia. Its, of course, is not the possessive form. That's a contraction of it is or it has. Its should not have the apostrophe there. It's the possessive its without the apostrophe. Another very, very common problem I see. Was that of Jesus Garcia. Police searched Jesus's car without a warrant. Now, this is my conundrum one. Plural and singular possessives are probably the most difficult things to understand. Strunk and White, if you look at Strunk and White and Garner, they explain it pretty well. I wish I had a blackboard here to show, but we don't have that. That's okay. I know, I'm from the dark ages. The PowerPoint I should have had is really what I should have had. Jesus is, so all singular possessives ending in S take apostrophe S. okay, with one exception, one class of exceptions. Anyone know what it is? Class of exceptions of singular possessives ending in S that only take the apostrophe as opposed to apostrophe S. Anyone? Yes. Yes, Jesus, exactly. Or classical names like Jesus, Moses, and Socrates. Okay, they take the only just the apostrophe because they all have another S in their. They mostly have another S in their name, and it would be awkward to say. And it simulates the phonetic too. It'd be awkward to say Jesus's and Moses's. Too many S's, so they take the apostrophe. Now, the conundrum here is Jesus's, not Jesus. Okay, Jesus obviously means Jesus in Spanish, a Spanish name for Jesus, but it's not the Jesus. All right, so the question is whether Jesus takes the apostrophe S or the apostrophe like the Jesus. My guess is, and I haven't seen this definitively, I've looked for it, is that it's Jesus' apostrophe S, that it follows the general rule and not the exception, because it's not the Jesus, and it's not pronounced like the Jesus either. So I think Jesus's with the apostrophe S is correct. I saw some of you taking the apostrophe, taking the last S out, which is a good guess because Jesus does take the apostrophe, but possessives are difficult. For example, the Joneses car, or Mr. Jones's car. How would you spell Mr. Jones's car? Anyone? All right, Mr. Jones's car would be with apostrophe S. Okay, the singular possessive would be apostrophe S. The plural possessive of Jones, the Joneses family car, would be Jones apostrophe. Okay, so the ES is counterintuitive at the end of Jones. It's any proper name ending in S takes ES to make the plural, and the plural possessive is just the apostrophe, not the apostrophe S. Okay, very tricky. And finally, on the hard copy that I gave some of you, not in the online version, I added another tricky thing. The court upheld the search based on the automobile exemption. The hard copy version says exception, which is what it is. I changed it to exemption just for the sake of adding sick. Okay, one of my fellow judges gave me a T-shirt as sort of a going away gift. It says, "Bad grammar makes me sick," with the sick in brackets. And so people who notice it, I ask them, what's wrong with this? Anyone know what's wrong with the sick here who got the hard copy? Yes?
It's not italics?
Yes, excellent. That's right. Very good. Sick is a Latin word, is still a Latin word that hasn't been fully incorporated into the English language. Those that have, like res judicata, are not capitalized because they've been incorporated and recognized as English legal terms. But sick is still a Latin term, so sick should be italicized or underlined, I guess, if you still underline citations and the like. On my T-shirt it should be sick should be in italics, not in regular. So it's a little bit of an ironic T-shirt that I'm obviously very persnickety. And I spent a lot of time on this. My new junior partner is also one of my former federal court students over here at John Marshall. He writes spectacularly well, and he researches spectacularly well the substance. He got a class action dismissed within about 3 weeks due to a clever legerdemain, if you will. But I edited his brief, and I corrected the Blue Book form. And he he deliberately didn't incorporate my Blue Book changes because he said, Jamie, you're the only judge in the state court system who recognizes Blue Book form, okay, who appreciates Blue Book form. I proceeded to text one of my chancellor friends who said, no, the Blue Book form is important, we recognize it. If not the judges, then their clerks often recognize it, who come from, or have law review backgrounds. So, yeah, you got to pay attention to Blue Book form. I'm not going to focus on Blue Book form here, but I did when I was teaching law school. So, yeah, pay attention to Blue Book form. And the appellate court has its own citation system, too, that's a little bit different from Blue Book. And I've spoken to a clerk there, a very scholarly clerk there, who notes the distinction. Okay, so don't give your reader, especially judicial readers and law clerk readers, any chance to look down their nose at your writing. Make your writing as perfect or as close to perfect as possible. Okay, so let's start on the substance of my presentation here. And by the way, I welcome questions. My favorite part of these is Q&A, so feel free to interrupt with questions at any time. And similarly, on what, do you have one already?
No, I'm just thinking
Okay.
to go to the microphone if they have a question.
Yes, right. Thank you. Yes, please go to the microphone if you have a question. Okay, I love them. So I start off with the KISS rule. Okay, everyone know what the KISS rule is? What the acronym is? Yeah. What is it? What does it stand for?
Keep it simple, stupid.
Very good. Exactly. Keep it simple, stupid. Okay. Judge Diane, actually Chief Judge Diane Wood, once gave a presentation to the Appellate Lawyers Association saying the word is brief. Okay. Not a lengthy diatribe. In fact, I posted my sentencing memorandum that I posted online. Did all of you get the sentencing memorandum along with? I actually apologized to the federal judge on Tuesday or Monday it was, saying, paraphrasing Mark Twain, saying, if I had more time, I would have written a shorter brief. It's a little bit lengthy, and I regret that. I think it's fairly well written. He complimented it as well as the federal prosecutor complimented it, but I personally would have preferred a shorter brief. Now, it could have been cut down to 15 pages, at most 20, but I was a little prolix at writing it. So less is more. KISS rule means less is more. Never say in more than one sentence what you can say in one. Never say in more than one word what you can say in one. Judge Shader's example to the U.S. Attorney's Office, I remember we had a seminar with Judge Shader at the U.S. Attorney's Office, was a simple one. Why use prior to when you can use before? Before is one word, prior to is two words. It's prior to is Latin-based, before is Germanic-based, which is preferred in good legal writing. And it's one fewer syllable, one fewer word, and one fewer syllable. Fewer, not less. Rule of thumb, if your sentence is more than 3 lines long, it's probably too long stylistically, whether it's officially run on or not. Okay? So, I would say, make your sentences 1 or 2 line sentences at most. Okay, there's nothing wrong with that. Again, less is more, and fewer sentences or fewer lines is better than most. So your reader has a very limited attention span, especially judicial readers. Okay, I'm speaking from personal experience now. You need to give it to them in bite-sized morsels, especially in the law, which is complicated enough that you want to break it down for the reader, for the judge, even for the law clerk. Okay, simpler is better. All right, so cut your sentences. There's nothing more discouraging to a judge or a reader than having to decipher through a multi-line sentence. It's very discouraging. It's like a long paragraph without any breaks, or a really long block quote. I remember one appellate brief in the State Attorney's Office. I was working on a murder appeal some years ago, and she had a block quote running for 2 or 3 pages at least. I was frankly appalled at that. If you're going to block quote, which I think can be effective, make it, maybe up to 6 lines or so, 6, 7 lines. Don't make it take up the whole page, because that's discouraging to the reader too. To make your sentences shorter, use logic in transitional words like however, and, or but. It's perfectly acceptable to start a sentence with a conjunction. Okay, don't pay any attention to the man behind the curtain, to the people who tell you that it's not appropriate. It is. You don't need a comma after the and or the but. A lot of people subscribe to that theory. And or but are perfect ways to connect thoughts, or you can use to connect sentences rather than putting it all in one sentence. Okay, therefore, thus, hence. Okay, logical transitions like that. That's how you make your sentences shorter. Okay, break it down. And there's nothing better than a staccato one-line sentence to express one thought. I mean, the rhythm of it is great. It emphasizes your thought in the one-line sentence. It's dramatic. Use it whenever you can, maybe judiciously. Maybe not every sentence. You can't make every sentence a one-line sentence, but occasionally intersperse your paragraphs with one-line sentences. It will make your writing that much more dramatic and impactful for the reader. Okay. Passive voice, my big bugaboo. All right. As far as I'm concerned, anti-passive voice or active voice is now the law, at least in the Seventh Circuit, as I've quoted a case from you by the other Judge Wood, Judge Harlington Wood, from a 1992 case called Torres from my office. This is actually when I was in the office, although I didn't work on this case. It's so important that I'm going to read it to you. The government asserts that law schools and law journals universally frown upon the use of passive voice, but the average writer does not consider this literary construction with such contempt. Okay, that's the government trying to weasel out of its use of passive voice, or its agents' use of passive voice, even though in the government generally we did not write in passive voice. We were mostly good writers, though not all. We eschewed passive voice, but here we had to defend the use of passive voice, at least by its DEA agent. Whether or not the average writer is contemptuous of sentences written passively is not the issue. The issue is clarity. One-line sentence, four-word sentence there. The issue is clarity. Good writers eschew, or eschew, some people say, the passive voice, not only because a sentence written passively is often not as forceful as a sentence written actively, but more importantly, because sentences written passively are often more ambiguous than those written actively. Okay, and that's the reason to avoid using passive voice. Okay, because it's not clear. It's clarity in writing. It's grammatically correct, but it's stylistically incorrect, and you should avoid it at all costs. Agent Giffrey's sentence, and they went on and named Agent Giffrey, although I'm not sure how important that is to a DEA agent, poignantly illustrates how a passively written sentence can lead to possible confusion. It is true that the sentence in the affidavit, quote, the brown paper bag carried by Torres was opened, revealing a white powdery substance to the undercover agent. Okay, so the passive there, of course, is carried by Torres and was opened. The key problem is was opened. Was opened by whom? Certainly doesn't indicate anybody else opened the bag, as the district court concluded. It is also true that the sentence obviously does not indicate who, in fact, opened the bag. If one is going to write in the passive, one should at least include all of the necessary prepositional phrases for clarity's sake, not because law journals and law schools require it. Okay? So the reason law schools and law journals in proper style require it or recommend it is for clarity's sake. Okay? That's the rationale for it. Okay? And it should be avoided at all costs. You should go through your writing and self-edit your writing. Sometimes spelling and grammar check will catch this, but there's really no substitute for human editing, which is why I actually started a side business called Edilex, which is on my website because of my frustration with bad legal writing. The passive voice is really problematic. Here's a trick that I use to catch your passive voice. If you don't want to go through, or you're having a hard time catching and writing, do a find search for ed. Put an ed space, okay, in your find function, okay, and you'll usually find past participles, which are often preceded by a form of the verb to be, like is or was. Okay, so for example, was opened there. If you search for ed space, you would catch opened, and if you find a form of the verb, a past tense or present tense of the form of the verb to be, usually is or was, then you'll know you've probably found passive voice. That's my trick, okay, to catch it. Sometimes, rarely, you need passive voice. Maybe you really don't know who opened the bag and you need to finesse it, but sometimes you need passive voice, but maybe one or two times in your brief at most. Okay, it'll make your writing a lot more impactful if you use active voice. Any questions about passive voice? I can't tell you how important this is stylistically. Any questions about passive voice? Okay, good. Typos. I think in one version I have TYTPOS, tiptoes, or something like that, just to illustrate it. Judge Wood, in her speech to the Appellate Lawyers Association, said, try hard not to. The reason was that they're distracting. Okay? They're distracting, and it reflects a lack of care taken in your writing. Okay? And once again, you can't rely on spell and grammar check to catch these things. Okay? There's no substitute for a human eye in catching these things, because your word may be a proper word, but it's the wrong word in that context. In that context, it's just the wrong word, and it's considered a typo. You can't rely on that. You have to go over it with your own eyes. So they are distracting, and it reflects a lack of sophistication in your writing that most judges and law clerks will catch. Trust me, they will. And it'll cause, what it does to a judge, at least me, it'll cause judges to look down at your writing. It'll cause judges to look down their nose at your writing and think that you're not that careful, and it will reflect on your lawyering. I'm telling you this. All right, it does, and it will reflect poorly on you as a lawyer. And I'm not just talking about typos. If there's occasional typo and you're not using passive voice a lot and your writing is otherwise good, that's okay. We'll give you a pass as a mistake. But if you use typos, glaring typos, and God knows I've seen enough of these briefs as a judge and as a lawyer, as opposing counsel, that it's embarrassing. You'll lose your credibility when you come in for oral argument. You'll have less credibility, and you're already starting behind the 8 ball. Okay? I'm telling you this because it's true. Okay, now my favorite part of the presentation, Posner's 19 anti-lessons. You all get this on the website? I love this. And how much do we have till 9 o'clock, Emily? Great. I'll try to keep it till 9 o'clock. Leave about 15 minutes maybe worth of questions. This is my first opportunity to go through them. I teach an MCLE on Behind the Robes where I just hand this out. And speaking of handing it out, when I started teaching legal writing at Loyola back in the 90s, I wanted to hand this out to my 1Ls, but my legal writing supervisor at Loyola wouldn't let me hand it out. She'd let me read it, but she wouldn't let me hand it out because she was afraid the 1Ls would take it seriously and that Posner wasn't being sarcastic, which he is being, and that they would actually do what Posner is suggesting. So I think she may have hopefully underestimated the 1Ls. So I couldn't hand it out. I could just read it to the classes I'm going to do now with commentary. Use the passive voice as much as possible to make unclear who was doing what to whom. We are asked to overrule Jones versus Smith. Enough said about that. We already talked about passive voice. And notice, though, he puts it as number one of his 19 anti-lessons. By the way, I should read the preamble a little bit. And this is from an article he wrote in 1986 called Goodbye to the Blue Book. I think he was advocating at the time, being a U of C professor, the Maroon Book at the time, which I later called the Moron Book, actually. I think the Maroon Book has faded away. We have one convention, one citation convention in this country. It's called Blue Book form. Okay, the academicians have come up with an alternative citation system called Allwood. Any of you familiar with Allwood? Any of you have heard of Allwood? Okay. Don't use it. Rebel. Be Ted Cruz on Allwood. Okay. Teaching appellate advocacy. It's called Herzog at John Marshall. I refused to teach Allwood. Okay, just refused to teach it, even though the competition was supposed to use Allwood. I said, you're on your own for Allwood. I'm not going to teach it because I just don't believe in it. And apparently, a summer associate down in Texas used Allwood form at her summer internship, and a partner threatened to fire her over her use of Allwood and not Blue Book form. Okay, so the idea behind a convention is that we have one convention. Okay, Blue Book is it. Okay, now in the appellate court, for their citation, I wish they just used Blue Book, and Allwood is a slight variant of Blue Book. You really should follow their own form because it's a court's form. I just disagree with their use of it. I think every court we should have the Blue Book is called a uniform system of citation. So I was brought up with the Blue Book. In my moot court competition, we use the Blue Book. So I'm a big advocate of the Blue Book, or at least one system, and the Blue Book has traditionally been that one system. To instill and that the great writers exemplify every lesson that students of the English language and teachers of writing seek to instill, and that the great writers exemplify, is turned on its head in legal writing. Here are some of the anti-lessons that our heavily student-influenced legal culture enforces. I don't know about student influence, I guess, on Law Review. But it shouldn't be student influence. It should be judge influence and good lawyer influence. Number 2 is be vague. Talk a lot about fairness, justice, rights, activism without defining any of these terms. Obviously don't be vague. I'm not sure that fairness, justice, rights, activism are good examples of being vague. To Posner they are. I'm not sure how much I agree with his examples. I don't think there's any wrong about talking about those terms in general terms if you can't be more specific. Excuse me. But yeah, don't be vague. Okay, if these words are construed as vague as they are for her, then don't be vague. I agree with the general rule. Number 3 is nominalize a lot, so it looks as if you're writing in a technical jargon. For example, a Fifth Amendment denial of due process claim rather than a claim that the state denied due process in violation of the Fifth Amendment. I'm not sure that I agree with this example. I certainly agree with the general rule. Don't nominalize a lot. Don't look like you're writing in a technical jargon. I mean, you are writing to lawyers and judges, so judges have a certain degree of sophistication. I don't have any problem, frankly, with a Fifth Amendment denial of due process claim. Maybe you do. I think it's tighter than a claim that the state denied due process in violation of the Fifth Amendment. And again, under my less is more theory, I don't have any problem with the shorter version. I think lawyers just understand that. So in the interest of conciseness, I don't have any problem with his example. I don't have any problem with the example that he says not to use. Number 4, use a lot of adjectives and adverbs. I know adverbs have come into disfavor in legal writing. I don't really understand why, frankly. I disagree with this one. I'll come right out, and I don't have any problem with adjectives and adverbs in writing. I think adverbs modify verbs or nouns, or other adverbs or adjectives, and I think that your writing can be enhanced by describing or modifying other adjectives, verbs, and other adverbs. I just have never had a problem with it. Maybe you did. That does seem to be a consensus in legal writing that they're to be avoided. But used judiciously, I just don't have any problem with it. I don't understand the avoidance. I just don't. So I disagree with rule number 4, and to the extent there's a consensus, I disagree with that consensus. I think adjectives and adverbs can enhance legal writing. And by the way, speaking of legal writing, another thing Judge Wood said, and obviously Chief Judge Wood said, and I obviously admire Chief Judge Wood in her writing, she said there's no such thing as good legal writing. There's only such thing as good writing. Okay? And that really had an impact on me. In other words, good legal writing should be intelligible for a non-lawyer reader, is the implication of what she's saying. I put that question actually to Scott Turow. He put on a seminar about novel writing over at his Sun and Shine, which is now called Denton's, I think. And I put that to him. I quoted Judge Wood, Scott, do you think that, and I call him Scott because he was in the U.S. Attorney's Office, not when I was there, but I'm on a first-name basis with him. Do you agree with Judge Wood's admonition that there's no such thing as good legal writing, only good writing? And he did seem to disagree with it. And I kind of disagree with it too. That novel writing, that creative writing is different from legal writing. That there is a distinction between good legal writing and good writing. For example, I think I'm a pretty good legal writer, but I think through good legal writing, I think I've lost my ability, frankly, to write in a non-legal way. I only think like a lawyer now. I used to want to be a novelist, actually, when I was right out of college, and I don't think I could do that anymore. I just don't have the flowery vocabulary or the flow, the style to write in a non-legal way. So I think I disagree with Chief Judge Wood the way Scott Turow did, that there is such thing as good legal writing that isn't necessarily good non-legal writing. Number 5 is make your sentences long. Obviously, I agree with this. This speaks to what I was just saying, and Judge Posner reinforces that. Number 6 is be euphemistic. For example, say not sex discrimination, but gender-based discrimination, not girl, but minor woman, not fired, but terminated. To some extent, I agree with that. Although, it's an issue of political correctness, and Posner is nothing if not politically incorrect. A lot of the sex in the law, law and economics. For example, my extrapolation of what he's saying would be, say not rape, but say sexual assault. Okay? Well, rape has, come to be fraught with, meaning, and sexual assault has replaced the term rape for some pretty good reasons. So I'm sure he would suggest that. But I think sometimes want to soft sell it a little bit, I agree with him on fired and terminated, by the way. I think fired is better than terminated. I don't like minor woman either. I hate the term minor, by the way. For someone under 18, it sounds like they're less important, like kids and adolescents are less important in some respect. I don't like the term minor. Would you call an adult a major? That's the implication of it. Call them a teenager, adolescent, or a child. I've always rankled at the term minor. Use long textual footnotes to make your work hard to follow and to avoid having to integrate your ideas in a logical structure. Long textual footnotes are good for law review articles, okay? And you can use them in, I don't think they should ever be long. You can use them the thought is you can use them in federal court, but not in state court. That's the general rule of thumb. And I think that's probably true. I think they're pretty significantly disfavored in state court because they're distracting. We have in my case, a higher volume of cases in state court where we really don't have time to look down at footnotes. They're a distraction, okay? In federal court, they have fewer cases, not less. Fewer cases, and they can spend the time to look at footnotes. Hence, I have footnotes in my sentencing memorandum that I probably would not use had I been writing a state court sentencing memorandum. They'd be distracting to the judge, who has a lot more briefs to look through. In any event, they probably shouldn't be long and textual, and I think my footnotes in my sentencing memorandum are pretty short. Number 8, use a lot of cross-references. See if you can make the reader spend his time flipping backwards and forwards in your work. That's true. I agree with that one. Supras and infras he's talking about. And I do use one infra. I usually don't in my sentencing memorandum. I said, see discussion infra passim. Everyone know what passim means, I guess. Usually found in the table of authorities throughout your work, interspersed throughout too many pages. So there's one case that I want to emphasize that I'm going to use in different subsections that I want to emphasize the judge that, be forewarned, I'm going to use this case in the future. And I don't intend for him to flip back and look, or flip ahead, rather, and look for all instances in which I cite the case, but I'm giving him heads up that he's going to find this case discussed infra. But in general, I agree with him. You should avoid uses of super and infra. In law review articles, it's okay. They do it all the time. But those are scholarly works in scholarly journals. So everything I say, by the way, most of what I say applies to briefs, okay, and memoranda, things that you guys would work on, not law review articles. The rules are a little different for law review articles, and those are student influence because it's law students who are publishing those things. Okay, so some of these rules go out the window, although probably not for Posner. Posner probably, I think, writes his law review articles and following his 19 anti-lessons or not following his 19 anti-lessons. Number 9, qualify everything you say with "I think" or "it could be argued" or "it would seem." Always weasel, one of my favorite lines, but never acknowledge genuine uncertainty about any proposition you advance. Affect certitude. I would agree with this. I don't think you should ever use "I think" or "it could be argued" or "it would seem." Certainly not in a brief. I don't know why you'd ever use the first person in a brief. Or it could be argued, it would seem. I think this is even more applicable to oral advocacy, frankly. Never even we submit or I submit interjects your views into what the law is or should be. Okay, my teaching tool in coaching moot court is always, you're Walter Cronkite. Okay. I'm dating myself again, but Walter Cronkite always used to sign off his newscasts with, "And that's the way it is, Thursday, September 26, 2013. And that incredible resonant voice of his. That's the way it is. What you say coming out of your mouth is the law. Okay, it's not what you think the law is or should be. It is what it is, and it should be. So, I would never qualify what you say. It could be argued or it would seem. And I would never weasel in your briefs or in oral argument. Number 10, always be stuffy, boring. Avoid contractions, humor, unless heavy-handed, or any other hint of informality. Never say though for although or till for until. And by the way, I've seen Posner used till a lot in his Seventh Circuit opinions. Always use the Latinate form of the word. For example, elevate for raise. Sound old. I love that. Sound old, and that is what a lot of writers do, and it is heavily student influence. Everyone wants to use, especially younger legal writers, want to use the Latin they learn in law school. Latin is to be avoided. For example, is the move to use issue preclusion and claim preclusion instead of res judicata and collateral estoppel. I'm not sure if I agree with that. Issue preclusion and claim preclusion are sort of the modern kind of hippy-dippy ways to use it, like, hi, I'm avoiding Latin. But I think res judicata and collateral estoppel are well enough understood to lawyers that, and those are just terms of art that I think we should skip with, although skip rather, and not necessarily avoid, although we understand what issue and claim preclusion is. My classic example, which is seeped into legal culture, into legal writing and lay writing even, which I call cop-ease, is exited his vehicle or exit his vehicle. Adam sees it all the time. Why not got out of his car? Okay, or if it's not a car, got out of his truck, got out of his SUV, okay, exited his vehicle. And people start using this all the time. They use it in court, they repeat what the cop says. Exited his vehicle is pretentious, pompous Latin forms of the words instead of everyday English. Got out of his car. But you'll almost never see that, if ever, in police reports. Unless the cop happens to be listening to one of my seminars, I guess. So I agree with that. I don't have any problem with contractions or humor unless heavy-handed. Interesting. I did once use a footnote, or I think in my first Seventh Circuit brief at the U.S. Attorney's Office. I started in the Civil Division, and I think I called a case, if I remember right, there's a case called Shadui, which I called shadowy. I called a shadowy case. That was probably kind of goofy. There's another example where the editors of my brief, the people I gave the brief to review, called it snide, whatever I commented, and I think that was a heavy-handed example of humor. But I don't think there's any problem with using light humor in your briefs. I think it's kind of entertaining. For example, in my sentencing memorandum, I said my client, it wasn't my client's cupidity, which means greed. Normally I'd use the word greed. But I wanted to kind of make a play on words with stupidity, only his stupidity, which motivated his crime. Okay, so I deliberately used a Latin kind of word, a big Latin $10 word, just to rhyme with stupidity to illustrate the difference in motivation. The judge didn't buy that, by the way. He said it was his greed that motivated his crime. Okay, enough said about that. So I am an advocate of what Posner says there, although some people aren't. I remember our legal writing professor in school said, never use while or never use since. Never use since instead of because since is a temporal term. But I disagree with that. I think since is fine as an alternative to because. It's an average everyday word that's come to mean because. It's one fewer syllable. And I think that informality is perfectly acceptable. I like to see it. I like contractions in writing. It's more conversational. It's fluid. Somebody called Posner's in Easterbrook's writing, my chief of Civil Division, called it breezy. I think breezy is good. I think good writing should sound like a good conversation. Of course, it's a little bit more formal. For example, I think it's okay to use the word enthused in oral spoken English, but not in writing. The word is still enthusiasm or enthusiastic, not enthused. It's not standard written English. But it is more formal, and it does have to follow some rules. But that doesn't mean don't use don't split infinitives, which I think we're going to get to momentarily. And I see we're running short of time for questions here, so I'm going to run through this. Number 11, banish individuality. Make your writing seem like the work of a committee. I think you know what's meant there. I think you should have individuality in writing. I think in my moot court brief I used the term in the summary of the argument, Congress didn't speak on an issue, so I used the term thunderously silent, which I think my moot court team has kind of laughed at. I think they left it in there, but that was kind of an unusual term, but that was my little stamp there, thunderously silent, instead of conspicuously absent. Conspicuously absent, I think, would be the more common term for what I was trying to convey, but I said thunderously silent, I guess, to emphasize the point. Number 12, be wordy. Repeat points. Include plenty of unnecessary detail. Never go back over your work to eliminate redundant words and sentences. I agree. Self-explanatory. Number 13, cite authority for every proposition, however obvious. Maximize the ratio of citations to pages. Save time and thought by copying string citations unread from previous articles or opinions. Well, I definitely agree with this. I think one or max two citations are enough, especially when they're the same thing. This leads to an issue that a named partner in a great small litigation, I'll mention his name, Mike Rothstein of Tabit DeVito, and Rothstein is a great legal writer, former president of the Appellate Lawyers Association, just told me last week about seeing a lot of parentheticals in his younger associates' work. Parentheticals explaining cases. I do use a lot of parentheticals in my sentencing memorandum to basically explain the holding of the case and the unique facts of that case. Especially the Blue Book recommends that you should use them when you use the signal CF, the comparative signals like CF and compare with, to explain the relevance of the case. But I agree with Mr. Rothstein. So that when you cite a case with C or no signal for the proposition that you stated in the text, you don't need a parenthetical to say the same thing that you just said in the text. Okay, so I agree with it to that extent. But if you need to explain the case's relevance that you cited for comparison, I think you do need a parenthetical to explain that. And I don't have any point with it. Then you give the judge a nutshell version of the relevance of the case. 14, use legalisms and archaic expressions, whether or not they're equivalents in ordinary language. Don't say that something is within the statute's reach. Say it's within its ambit. Don't say this case. Say the instant case or the case at bar. Now, that I really agree with. Okay, the instant case is really seeped into legal writing. The appellate court uses it a lot. I see it all the time. I agree with them. I used to comment on my students' papers at Loyola saying, "Is this oatmeal or something? Just add water." I don't like instant case. There's nothing wrong with this case or that case. Okay, this case means the case that under discussion, the case that you're writing about. That case means the case that you just cited. This and that. You don't need instant case or the case sub judice or the case at bar. Okay, just say this case. It's simpler and more direct. Okay, instant case. It's a pet peeve of mine. Don't call an issue new. Call it one of first impression. I don't know if I agree with that one. If it's a case of first impression. I think that's acceptable. Don't say a contract is broken, say it's breached. I don't have any problem with breached. I mean, breach of contract is a normal term. I disagree with him on that. Never call the parties by their names. Call them appellant and appellee, or better, plaintiff appellant or defendant appellee. Make the reader think you wrote your piece right after waking up from a 200-year sleep, like Rip Van Winkle. That I do agree with. I would call them by their names after you've indicated in the parenthetical in quotes, what you're going to call them at the very outset of the brief. Okay, for example, I call my client Mr. So-and-so, Mr. his name, rather than defendant or by his last name. I want to connote a sense of, or bring to the judge's attention a sense of respectfulness towards my client. Of course, his co-defendant I call by his last name all the time, or co-defendant sir, because I want to diss him. And of course, the government. The prosecutor always refers to the defendant as defendant, standing behind him and pointing at him to make him squirm. That was how we were coached to do at the what we were coached to do at the U.S. Attorney's Office. They want to objectify the defendant. Use names and not first names. That's too smarmy. Certainly in writing and orally, I think first names to humanize your client are different. Is different. 15, be abstract, not concrete. Never try to make the reader visualize what he is reading. I agree. I think concrete writing is better writing. 16, use cliches, tired metaphors. Don't say, this law will deter people from speaking out freely. Say it will chill their freedom of speech. Chill is the accepted cliche for describing the effect of a law that places a burden on free speech or indeed any right. Don't try to find a fresh metaphor. Well, I sort of agree and disagree with this. I think, chill has become kind of the accepted, chilling free speech has kind of been the accepted metaphor for inhibiting free speech. Maybe inhibiting is better. Again, there are certain conventions, I think, in legal writing that have become acceptable. But, for example, Hobson's choice or sword of Damocles are the kind of accepted metaphors for dilemmas. Sometimes I'll throw a fresh metaphor in there: Procrustean bed, or caught between Scylla and Charybdis. Okay. When I really want to get fancy and arouse the reader's attention. Sometimes I'll do that. Sometimes, but beware of that. That the reader's probably going to have to look that up. Look up the analogy. But sometimes it is nice to throw a fresh metaphor in there, I think. Scylla and Charybdis isn't too unknown. Procrustean bed is a little bit more arcane. But you may sound a little bit more scholarly and sophisticated if you do come up with a fresh metaphor. But 17, adhere rigidly to every outdated rule of grammar you can find. So never begin a sentence with but or and or however, which I was just talking about, or end it with a preposition. Never split an infinitive, however awkward the alternative. That's the classic example of that is to boldly go where no man has gone before. The alternative would be to go boldly where no man has gone before, from Star Trek. To boldly go, it just sounds better and more dramatic. Okay, if you look at Strunk and White, they have a big riff on splitting infinitives. They say there's precedent for splitting infinitives going back to the 14th century. And I'm a big advocate of that. Okay, I think it's an outdated rule of grammar not to split infinitives. So I think you can and even should when it just sounds better. Okay, you have to have an ear for legal writing. It should sound good when spoken. Never omit the noun after a demonstrative pronoun. Allow no paragraph to have fewer than 3 sentences. Never omit of after all. Always use and or before the last item in the series, and never use since for because or while for although. That was the exact rule, actually, that our legal writing professor pointed out to us. I agree with them on most of these things. Since and because, while for although. Some of them are idiosyncratic to Posner, I think. You just have to use your discretion. 18, be sure to use a lot of unnecessary commas to slow down or perhaps stupefy the reader. Use lots of italics, hyphens, and compound words in the German manner, like rulemaking and fact-finding, to confuse and distract. Commas, I definitely agree with. You should avoid any unnecessary commas. For example, I think the government style manual says to always put a comma after the year in a date. Okay. Yeah, you're disagreeing with that too. Yeah, I don't do that. I don't follow that rule at all. At the beginning of a sentence, and on September 26th, 2013, Judge Shapiro gave a presentation on legal writing. That's okay at the outset of a sentence when a comma clause would be appropriate. But in the middle of a sentence, the comma after the year, it breaks up the sentence. But according to the government style manual, the year is a separate comma clause, and it should be separated with the second comma. Disagree. So generally, I do agree with Posner on that. Although I don't have any problem with rulemaking or fact finding. Actually, I don't think that's. I think that's tighter. So some of his examples, I do disagree with. Finally, write in a superior, arrogant, dismissive, sarcastic manner, sort of like he's writing here. It's kind of sarcastic. Insinuate that only a fool or a person untutored in the mysteries of the law would disagree with you. Make clear that all legal questions have a right and a wrong answer, and that yours is the right answer. Make certitude the test of certainty. I agree with his first sentence, and I guess his second sentence. You shouldn't write in a superior, arrogant, dismissive, sarcastic manner. I think you can say the defendant is wrong or the plaintiff is wrong when you're talking about the other side. I had a partner explain that to me one time earlier in my training as a junior associate. But I think that when you're kind of supercilious like that, to use a $10 word, I think it speaks poorly of your writing. So that's. I only left a couple of minutes, a lot less time than I wanted for Q&A. But we have a few minutes for it, right, for Q&A, and maybe if we run over time, I'm going to stick around if any of you have individual Q&A. I know some of you, at least me, I'm inhibited about asking questions and answers in a group. But does anyone have any questions about what I've said or anything that I haven't said? Anyway, yeah, Adam, I think, can you go up to the microphone, because for the people on the webinar, finally getting used to this. Last time I got off camera and I went down into the audience to illustrate something about cross-examination, and Adam was here actually, and that was a no-no.
Thank you. Regarding capitalization of the word "the court," when you're addressing a court, for instance, in a motion for reconsideration to show deference, do you capitalize the word "court" in that instance? I
think there to sort of suck up, if you will, to the court, I think it's probably appropriate. I do that to elevate the importance of the court in their own mind, in their mind. So there, I think it's acceptable. I think it's probably technically incorrect when not referring to the Supreme Court, but there I probably would and do capitalize the C in court. For district court on appeal, your lowercase district court. You don't capitalize district court when you're talking about it on appeal, because you're not talking to the same forum. You're talking to the Court of Appeals, which probably looks down their nose at the district court anyway. At least depending on who the district court, meaning red judge, is. So I think it's acceptable to capitalize court when you're addressing the court to show respect and deference. So it's a great question, Adam. Thank you.
And as long as I'm up here, were you trained that in parentheticals it must start with an ing, holding, reasoning?
No, I don't think I was trained that way. I know a lot of people do that. I don't think it's necessary. I think it just adds more words to your parenthetical. And I think it's understood. In other words, reasoning and holding is understood from your parenthetical. So I think that just adds more unnecessary words. Of course, it holds or reasons that. Otherwise, why are you talking about it? So again, less is more. I would try to omit those words whenever possible. And also, of course, omit the little words, the articles and things like that whenever possible. That's a Blue Book rule. So
great. Thank you.
Anything else?
No?
No? Anyone else? Are you leaving or coming for a question? You got to leave. Yeah, thank you for saying it. It is 9 o'clock, so all of you are free to go now. Any webinar questions? Nothing? I guess I've answered all of your questions. Amazing, in one fell swoop. I can't believe that, because usually I do get Q&A. Maybe I haven't left enough time for it. Yes? Great.
Hi. What is your view on the use of the phrase "whether or not"? Don't you think the "or not" is redundant?
Yes, it usually is. Again, it depends on the context. I think, again, under the less is more theory, if you can get away with whether and it sounds good, I think whether is better. Less is more. I think sometimes whether or not, like, for example, in an issue presented, I would definitely omit the "or not." I would just say whether and then the issue. Again, it's a matter of, so I don't think whether or not is necessarily incorrect, but it is redundant. You're right. It's a really good point. I would default to the whether unless it sounds like not enough. Like, for example, in order to. As another example, I remember the grammar book studying for the SATs or the Standard Written English test back in my day. They said, don't use in order to, just use to. Well, sometimes if you've already used the word to, you need in order to distinguish it from the previous sentence. So sometimes in order to is necessary. But again, just like whether or not, to instead of in order to is more appropriate. So great question. Thank you for that. Yeah. Anything else? I know we're over time here, so.
There is one from the internet.
What?
There is one from the internet.
Oh, great.
Okay.
Uh-huh.
Here's one from the internet.
Okay.
What are some good guidebooks we can use for writing?
Oh, excellent. Great question. Okay, I would, two. Okay, less is more. Strunk and white, I think, is great. It's not specifically for legal style, but I think it's great. That's under Chief Judge Wood's example. There's no such thing as good legal writing, only good writing. It's generally applicable to strunk and white, and it's short and sweet. I get all of my rules on plural and singular possessives from strunk and white. Go ahead and split infinitives from strunk and white. I think it's a great style manual. A longer manual. Brian Garner is really the as I said before, the doyen of legal writing. I mean, that's, if you really want to delve into it, get one of Brian Garner's books. I think that's the Bible of good legal writing, and I would follow him. So Strunk and White, the short version, and Brian Garner, the longer version. So my training, if you will, I'm sort of self-taught, I guess, has been from Strunk and White and Garner. Okay, so those are the two I'd recommend.
Okay, there's one more.
Good.
What is your opinion on the use of two spaces after a period as opposed to one space?
Great question. I love it. And somebody did close up the space, I think, in the writing. That wasn't one of the mistakes I made. And sometimes, of course, your computer makes a bigger space, and it looks like more than two spaces, just to fit it in the double justification. By the way, I think you should double justify. I think both margins should be justified. I had that debate with the chief of my civil division, but that's a great. And I got into that with one of my legal writing students at Loyola, who was an advocate of one space. And I later found out that apparently the one space school was from the old 8088 computers when space was at a premium. And that one space became the mode because to save characters, to save bytes, I guess. So I think two spaces is appropriate. He was in publishing with the Princeton Review, where they apparently use one space. I'm still a traditionalist about that, and I use two spaces. I think two spaces is appropriate because computers have a lot more storage space now, and we don't have to save room by single spacing after a period. So great question, and something that's bothered me for a long time. Thank you for that one. We have another one? No? Too bad.
I have one more, Your Honor.
If any of you have to leave, go ahead and leave. I won't be offended, I promise, but I have time.
What's your thought on using the introductory language, comes now comes? It seems superfluous.
It seems superfluous, and also under Posner's rule, it's Latin. It sounds old. Always weasel. It just sound old. I think it's pretentious, old Latin. Now comes the plaintiff. In capital letters and everything, kind of like wherefore, the wherefore clause. It's traditional, especially in state court. And in state court, judges are used to it. I think you probably still should use it in state court, but I disagree with it, frankly. In the prayer for relief, the plaintiff respectfully requests damages in an amount in excess of $50,000. I'm not even sure I agree with that. I think you should, express an exact ad damnum. But just to give you an idea, I think more detail is more there. So yeah, I think that sounds old, and like instanter. Everyone uses instanter in state court. Why not just say now? Okay, instanter is like the instant case, but everyone uses it as a convention in Cook County. But I would normally prefer now. I'm not going to go against that convention, but I agree with you, Adam. Yeah.
Thanks.
What else? Do you have another question? Great. Love these.
I have several partners that I write for, but depending on who's in the office, the person who gave me the assignment may not be the person who reviews it. So everyone has very different styles, and I feel a little blindsided sometimes because, they say,
they're wrong.
I want a 2-pager, so I, think I have it tight and right, and they're like, do I need to look at it? And I said, well, I think it's good, or I wouldn't give it to you, and then it comes back all, torn apart.
All read
but
are they right or wrong? Are they good suggestions, or are they wrong suggestions?
Well, I think it really is stylistic on a lot of things, like to, put in more explanation, to break one sentence into two. It's not a long sentence to begin with, but, to add stylistically to make it kind of sound a certain way, or things like that. And maybe this isn't
No, it's great. I think I know what you're saying. I mean, style is style as long as it's not disfavored style like passive voice. which is clearly wrong and to be avoided. In editing my students' papers and reviewing them, I'm usually pretty deferential to the substance of what they say as long as I can understand it. So if a partner who's ultimately, I guess, responsible for the work wants certain thoughts put in there, as long as it's grammatically and stylistically correct, as long as you can understand it, I don't really have a problem with that. I mean, you just do the best you can. I mean, you disagree with the style, I guess,
yeah. Yeah,
But
I mean,
these are-
because I wrote it in the style that I think was appropriate, and maybe it's that I'm being more brief and less legalese
wordy?
than they want it to be. So
yeah, I'm sure your writing is better. Usually the student's writing is better than the partner's. It sounds like you know what you're doing, but in the interests of firm politics, I guess, you probably need to defer to them and incorporate their changes. That was always a big bugaboo with me. I would obsessively correct my students' writing at Loyola, and they would not incorporate my changes. For example, my junior partner spent a lot of time correcting his Blue Book form, underlining the period in id. He still uses the underline. And by the way, I scoured the Blue Book for that in doing my moot court competition, whether you underline the period in id. You do, by the way. An easy way to avoid these underlining problems is just use italicization. That's a real good way to avoid the problems with underlining, because italicization. I say I'm a better writer than a speaker. It gives you an alternative to use italics or underlining. So, yeah, in the interest of firm politics, and I guess you have to defer to them. But it depends, I guess, on who the partner is. If you really want to take them on and you want to defend your writing and say why this is better, I guess you can and probably should. I can tell just by listening to you, your writing probably is better, but. Ultimately, I think you have to defer to the partner if they're putting their name on the brief. So I feel your pain.
Well, and even going through the Posner thing, I mean, it's pretty dramatic how many differences there are and how, different conventions, even by court, there are. So, you can say there's a right one maybe with a certain court, but even with a certain judge, there's a, right way to write an order and a wrong way that may be okay.
To draft an order, you mean handwritten order, you mean, in circuit court?
Well, just for what the drafting language is, seems to vary judge by judge. Oh, I don't like it when you say this or that, so I don't know. I guess you just have to go with what
the
person in charge wants.
Especially the judge, maybe a little less so the partner. I once had to draft an order. A judge basically dictated the language in this order. It was like one run-on sentence in all kinds of legalese, and it was in my handwriting with my name on it too, and I felt horribly embarrassed by it. It was like it read like a patent. Okay, just one run-on sentence, and it was horribly embarrassing. It was clearly identifying my handwriting. I print, and it's pretty identifiable, and my name was on it, and I was horribly embarrassed, and I had to explain to her, I didn't write that. That's not my language, and I had to disclaim that. But the judge basically dictated to me what he wanted the order to say, and it was just awful. So, yeah, if the judge has a specific style, I mean, a lot of judges, frankly, don't know how to write. I'm probably one of the more persnickety judges was in the circuit court, and a lot of judges would probably. I wound up editing a lot of other judges' work, and they appreciated it. But a lot of judges probably think their way is the right way when it's clearly the wrong way.
My final point,
Sure.
and then I'll sit down and let you answer.
It's okay.
The other issue that I sometimes have that I differ with the partners is how much background information do you have to do, like on a motion? How much can you assume that the judge either knows about the case or the law, or that they can pull from the docket? That's also a point where where our views differ, and I guess that maybe also.
Yeah, no, and this brings up a point I should have mentioned in my own writing. For example, I don't know if you're talking about this, but for example, in the standard of review in an appellate brief, or more importantly, the standard for a summary judgment motion, or a standard for a 619 or 2615 motion, you really don't want to get into that much, and it's coming at the beginning of your brief generally, and sometimes the judge won't get past the first couple of pages of your brief, so you're missing an opportunity to put the good stuff, the important stuff on the first page. I've started advocating for putting a summary of your argument in bullet points right on the first page, just and you know, making the standard of the 2619 standard an addendum to your paper. I think Adam read one of my sentencing memoranda, and a lot of it was sentencing analysis. That was at the beginning after the Booker case just came out, so I think it was important then. Now, in my sentencing memorandum, I probably went into too much detail that the judge probably knew, but it was 11th Circuit law rather than 7th Circuit law, so I felt compelled to let him know that I knew the 11th Circuit standard. So I did spend a couple of pages on sentencing analysis, which the district judge in Tallahassee probably already knew. But yeah, you're wasting valuable space at the outset of a brief by getting too far into the standard review. And I know you want to shape it. Summary judgment is a drastic remedy which should only be granted in limited circumstances. I know you want to shape it, but most judges already know the standard of review. Okay, they know the standard for granting a summary judgment or a motion to dismiss. I would put that off until a little bit later, until maybe after some of the argument with bullet points. They'll appreciate that. I think that's a good way to go. And if you do it at the beginning, make it as short as possible, because you should assume that in terms of the background information that the judge, in terms of that kind of background information that the judge knows. Are you talking about factual background information?
Both.
Okay.
Sometimes you want to, frame what the issue is, but you're just doing something small. You have to say what all of the history of the case and the procedural history, as well as like the standard review. Because sometimes, I've seen summary judgments where there's 2 pages of the case law
for the summary judgment standard, right? If the partner wants more of a factual basis, more of a factual summary, and he thinks it's necessary for the judge to understand the case, I agree with you. Less is more, and only give the judge, like to quote Joe Friday from Dragnet, just the facts, ma'am. Okay, just really the minimum necessary to understand your case, just the key facts. I completely agree with you, but again, if the partner thinks more is necessary and to be wordy and prolix about it, I guess you got to do it. And if the partner is someone that you can sit down and have a real conversation with, saying you disagree with, to take them on, then I would try to do this and explain to him why this isn't necessary. Okay, so I agree with you. I just think less is more. And the judges don't have time. We pour a lot of effort into these briefs as if the judge is going to read every word. And you should make it grammatically and stylistically correct, but the judges don't have time to read every word. They have a volume of briefs. In my MCLE seminar, I talk about, I have a video of Lucy and Ethel at the chocolate factory. We have the chocolates coming out fast and furious, and Lucy putting them in her mouth and in her apron and just not having time to get to them all. And those are the cases that the judges miss because they simply don't have time. They're simply overwhelmed by the number of motions they have to read. So, brevity is the soul of wit. Less is more, KISS rule, all that. I agree with you that less is more. And unless it's absolutely necessary, again, you have to defer to the partner, but it gets pretty discouraging when, you have long-winded statements of the facts and the judge is thinking, so what? Let's get to the guts of the matter. And judges use abbreviated ways to get to it. Sometimes they'll start with a reply brief to cut to the chase. Okay, they'll know what the issues are winnowed down to, because the reply brief is usually shorter, and then they'll work their way back from there. So, keep in mind the volume of cases. You have all the time in the world, or you can build time on writing a beautiful brief. And again, the word is brief, but judges have a very limited amount of time. I know one judge in the law division, she would look at the depth transcripts for summary judgment motions, and as soon as she found a genuine issue of material fact, she'd stop reading. Okay, and that would be her genuine issue of material fact to deny the motion. Now, it kind of rendered oral argument unnecessary for the defense side, because what if the lawyer talks her out of that issue being a genuine issue of material fact, and she doesn't have anything left to fall back on. She doesn't have an alternative. But you need ways to abbreviate your work. Okay, you don't have time to read through the entire depth transcript, and you just got to give it to the judge in bite-sized pieces. okay? Keeping in mind the volume of cases, especially in state court, that the judges have to plow through. In federal court, it's a little bit different. They have fewer cases. They have more law clerks, generally more scholarly judges who probably have time to read it. But in state court, you really do need to give it to the judge in bite-sized pieces. Okay, so I agree with you, not them. So, it depends whether you want to take them on or not. Can I answer anything else for people? Again, I'm here as...
All right, there's one more quick question online.
Oh, online? Okay, we have somebody coming up. You can stay up there. Can I answer the online question first? Great. Uh-huh.
In a brief or memo with footnotes, instead of using supra and infra, should we just repeat the citation?
No, I don't think so. I think if you've... Well, I think you can use supra. Actually, you know what? No, supra and infra are really reserved for law review articles, scholarly law review articles. You really shouldn't be using supra and infra in briefs and memoranda, okay? You should use the short version of the citation form, okay? That's what the short version is for. So just use the first name party and 165 ILAP 3rd at the page number without the district and the year, okay? The full citation form. So, no, don't use supra and infra because that's an unnecessary word and obliges the reader to flip back and forth through your work like Posner discourages. Okay, so that's what the short form of the citation is for. Okay, so I would avoid that definitely. Okay, yes, question from the floor. Live question.
What are your thoughts on parentheses in legal writing? Not parentheticals, but like in the text of your writing. You think that's too informal, or?
I don't think they're too informal at all, and I notice Posner uses them all the time. You use dash clauses, the M dash and N dash clauses to set off thoughts. I use parentheticals all the time as kind of Shakespearean asides. I think that. Parentheticals are perfectly appropriate. Dash clauses are good. They add a little bit of a dramatic effect. I don't think they're distracting at all, as long as they're not really long. I mean, the shorter the better for parentheticals because it's a side thought. But I don't have any problem with them. Some people may. I think some people are incorrect if they have a problem with parentheticals or dash. I think dash clauses can be very dramatic. I like dash clauses. Not too many of them. And you mix them in with parentheticals. Garner has a good discussion on when to use parentheticals and when to use dash clauses, which are more set-offs than others. I think the dash clauses are more set-offs and considered stronger set-offs than parentheticals, I believe. And comma clauses are even less set-offs than that. So you got to use your discretion and think about what sounds good. You have to have an ear, ironically, for good legal writing. But I definitely don't have a problem with that. And I know Posner uses them all the time. This reminds me, by the way, of a great example of good and bad writing. And this isn't legal writing. But anyone read The Stranger by Camus in college? Stranger, a couple of nodding heads? Okay. It's pretty short. I recommend it it's a classic, first of all. But the writing at the beginning of The Stranger is really, really good when he's at his mother's funeral and he's kind of indifferent to the death of his mother and he's thinking about sex and food and worldly things instead of mourning his mother's loss. And really short staccato sentences, which I think are a great example of good legal writing and good any writing. And then at the end of the book, he starts getting windy for some reason when he's contemplating his own death for murdering someone on the beach. He starts getting really long. So I think, I don't know why he does that in the book, but the contrast in styles from the beginning to the end of the book are, I think, a real good learning experience, a real good example of good writing, or at least legal writing, and bad writing. Okay, beginning good, and even if you just read the beginning, the first few pages of The Stranger, and the last few pages of The Stranger, I think you'll see the difference. Okay, even if you don't read the whole thing, that I've always thought of as a great learning tool for good legal writing and bad legal writing, and maybe good writing in general and bad legal writing. So I recommend. You can probably get it online. I'm sure it's in the public domain. Just read the first few pages and the last few pages, and I think you'll see what I mean. Another question?
I had one other question.
Sure, please.
I've noticed in judges' opinions they never use an Oxford comma. Is there a rule in legal writing where you can't use an Oxford comma? Because I prefer it.
The Oxford or serial comma, yeah. Garner recommends using the Oxford comma. The serial. Does everyone know what this means? In other words, in a series of 3 or more terms, like first, second, and third, whether you use a comma before the conjunction, first comma, second comma, or no comma, and third. We grew up learning that the Oxford comma, that last comma, is optional. But Garner now says it's not optional, and so I've taken to using it. Sometimes I used it sometimes. Sometimes I'd use it when it was first, second, and third, a real short series of phrase. I would not use it when it was a longer series, multiple word series. I would use it to set it off a little bit more. But now I use it all the time, the Oxford or serial comma, in a series of 3 or more terms before a conjunction. Okay, so I would recommend using the Oxford comma. After all, it's from Oxford, so I could be more definitive. The people who wrote the Oxford English Dictionary. So I've taken to using it all the time now. So I would recommend it, and Garner does too. Great question.